Hi everyone. It's morning for me, but afternoon for you. So it's normally the other way around for us here. But thank you for the invite and allowing me to present here today. Gonzalo mentioned it. MOUs is one of the good practices that have been implemented, trying to bring intermediaries together and fight this issue of counterfeiting. But it's important to know that it's not just e-commerce or marketplaces that are being misused or their services are being misused for IP infringements. This is across the board when you try to get one good from A to Z, so to speak. So what we have done in the observatory and the UIPO is trying to look into specific intermediary services and try to understand how they are being misused in terms of IP infringements. So if I move, let me see if this works. Yeah, so we have done so through an expert group that we have established in the observatory. One of our speakers, Dan here from Alibaba, is part of that group. But this group have gone through various intermediary services to try to understand them, but also see what type of trends that occur, so what the IP infringers are doing, but then also challenges for the intermediary services themselves, but for right holders to and law enforcement authorities to enforce their IP rights. But mainly then good practices put in place by these intermediary services to combat that misuse. So you will see from this slide, we have gone through quite a lot of different sectors. So we started out with e-commerce. That turned into a specific project. I'm not going to go into that in more details today, but we've also looked at domain names. You have payment services, social media. Transport and logistics is not online. Well, some of it is online, but that's another intermediary services that are being misused to transport the goods from A to Z, so to speak. We have looked into live event piracy, apps and app stores, search engines, and now the last paper that we will publish here this year, beginning of December, would be on online ads. So even not maybe in terms of counterfeits and obviously online ads are being misused in the sense that they promote places where you can go to have online content, but also to buy counterfeits. But it's also being misused in the sense that it's a second revenue stream for these IP infringers. So they're misusing these services to earn money on ads that they publish, or so they are using the ad tech intermediaries to gain money. So we've done all these papers. It's given us an understanding on how these different ecosystem works, but they're also very specific to the sector they're in. So when we went and had an overview of these papers, we realized that the good practices put in place, they follow a red thread. So they are pretty much similar in each of these ecosystems. Obviously a bit adapted, but they are quite similar, but it's hard to get an overview. So we have then started trying to create a repository. So what does that mean? It's a repository or a document at the moment, collecting all the information that we have in these different discussion papers and trying to make a generic classification, if you want to, or categorizations of good practices and online threats with specific examples connected to it. So it's more a horizontal view of these different ecosystems rather than these sector-based silos that we have looked into up until now. So what we want with this is to give our users, but mainly now as a first step, internal overview of different sectors to see if we can draw some conclusions from that. But then the idea is to keep these up to date. So every kind of 3 months, we will try to make an exercise into updating new good practices, or if we see a new trend and in which sector. I'll show you how we've broken it down a bit later. One caveat is that, so the MOU, as I said, is one of the good practices put in place. What we don't really include is regulatory obligations, because it's not really a good practice. It's an obligation for any intermediary to follow. But with new legislation in the latest papers, we are referencing legislation such as the DSA or the Digital Service Act, just to make that comparison to see what are the intermediary services doing that might go above and beyond their strict regulatory obligations. So in order for us to do this, first, if we look at good practices, in the beginning, when we started writing these papers, we thought that they would be very specific to the sector that we were looking into. But in effect, most of these good practices are the same across all intermediary sectors. They might vary a bit or differ, but in broad strokes, they are the same. And we did like a top categorization of these good practices. So we started with terms and conditions. So most of the intermediary services, or well, I would say all of them, have some type of terms and condition that regulates the use of their services. And if you breach those, there's certain penalty actions put in place. Know your business customers. So most of them also have some type of process put in place in order for the intermediary service to know who they are dealing with in terms of the use of their services. You have internal kind of risk assessment system to detect suspicious actions or activities or users, but also monitoring systems. Most of them also have some type of notification system. This is more depending on what type of intermediary we're talking about, but most of them have some type of notice and action system, i.e. if you, as a right holder, you see that your brand is being misused, or as a third party or just a user of the service, you notice that something is not right, you can file a notification with the intermediary through their own kind of notification system. Then we come into these corporations. So you have corporation activities with specific IP right holders. So the intermediary service and the IP right holder, they kind of have a corporation put in place, and they do target actions. You have the cooperation with public and law enforcement authorities, so the likes of the MOU. And it falls under the voluntary cooperation agreements as well. Then some of these intermediaries, what we noticed is that they do a lot of IP awareness and communication campaigns. So it's not only us as a public institution that preach the value of IP and the importance of respecting it, but also intermediary services are doing the same. And then you have some judicial and administrative processes. That part is very specific for certain intermediary services, such as live event piracy, but it's part of this repository anyway. So if we go in, and I'm going to show you a couple of slides, and as Jen pointed out, I'm guessing these will be shared. I'm a bit conscious about time, so I'm not going to dig in too deep in all of these different kind of categories, but I'll give you a couple of examples, and then you can read the presentation once you receive it. So in terms of terms and condition, here we saw kind of different 5 different type of subcategories. So we had terms and conditions, so IP-related policy as a condition of use. And what do we mean by that? These are kind of provisions defining acceptable or prohibited use of the service in relation to IP protection and IP enforcement. We have AI AI-related policy. So this is more intermediary services that offer a possibility for their users to create something that uses AI. So an example will show, I'll show you it later, but for example, in the app ecosystem, you have users who kind of create apps that allows their users to create content using AI. And all of this is trying to kind of figure out who is controlling what in that type of ecosystem. So there's policy related to that a developer of an app needs to put some safeguards in place so this AI is not using third-party IP rights. It also needs to put in some type of notification system that allows you to report misuse. Then you have policies to respect specific IP rights. It's very specific to certain users. You have also policy facilitating IP enforcement. So this is actions that the intermediary services can take against users of their services that are misusing IP or conducting IP infringing activities. Then some, as I said, some of these are very specific in terms of the sector. So we have policies to disincentivize IP infringing activities or compensate affected users. This is more in relation to the payment industry. So if I go in here, we can see then some examples. So the idea of this repository is like a tree structure. So you have this top line of terms and conditions broken down in subcategories, but under these subcategories, the idea is to then provide the user or the stakeholder that wants to read this with some examples. So you can see here in terms of domain names, there's a couple of registries that have put in their terms and conditions that you're not allowed to register a domain name that's infringing in someone else's IP rights. Same with search engines that you can't use content or material in a way that it's violating someone else's right. Same goes for paid search results. So if you contact Google and you want to come up under their kind of paid search, you're not allowed to use anyone else's IP right without prior approval. In terms of AI, I mentioned it, but this is, we can see here for app stores, for example, that apps that are generating content using AI must comply with existing policies. They have to ensure that their app doesn't generate offensive or misleading content. It can't also infringing in someone else's IP right. So what we're trying to do here is kind of give a short summary of the policy, but then also give a hyperlink or a link to the certain kind of places where you can find these type of policies. Here, for example, policies facilitating IP enforcement. Here, payment, for example, some of these intermediaries are withholding funds if these IP infringers are doing something that they shouldn't do. Here you have also repeat infringing policies. So, for example, if in this case, then an app store is detecting a person who's kind of registering new accounts and do IP infringing activities several times, they have policies in place whereby they can terminate their account. Then, if we go to the Know Your Customer good practice, there you have 4 different subcategories that we have identified. So we have identify contact details verification. So this is an intermediary doing some verification of the identification information provided by the user. there's a difference between sometimes if you have a user that is a business, you have to provide other details than you have to do if you're a private person, for example, your company registration number or VIT number or something similar to that. Then you have external use of sources. So some of these intermediaries are using third-party providers to help them verify the information given by a user. So this is something extra that they have put in place um, just to guarantee that they know who they're dealing with in terms of people using their services. And then this could be identification, verification for specific activities. So depending on what services the intermediary are providing, you have measures put in place specific for certain type of activities. Then if we go further, these risk assessment systems to detect suspicious activities or users, these are normally put in place by the intermediary. So either they use a third-party service or they have something put in place internally. So the first one is a system assessing users' registered identifiers. So for example, a domain or an app name or the social media username. So they put this system in place to kind of assess if this user is likely to infringe in someone else's IP right or if it's their own. Then you can have not just you can use different type of assessment systems to try to detect risk for IP infringing use. But then also systems put in place to detect suspicious activities. So some of these are very specific to certain sectors. So when we talk about transport and logistics, for example, you can see where the goods are coming from or where they are supposed to end up, and you can use all that activity, all those kind of information to make a correct risk assessment system, as a correct risk assessment. So if we have here we have some examples again. So apps and app stores, they can review apps created by certain developers before they publish it. They go through the kind of meta how do you say, the meta details of the app, just to make sure that the app is acting the way it's supposed to act. In the domain names sector, URID, for example, is using an abuse prediction and early warning system. It's a system they put in place to assess how likely it is a domain name can potentially be used to in an abusive manner or for IP infringing activities. There's something similar put in place by the Italian registry as well. And here we have these multi-factors, so using different type of system to make risk assessments. This is very specific for the payment industry, but they have a collaboration in between themselves. They put up certain blacklists, if you want to, that detect IP infringers or illicit actors, just to make sure that they don't go from one payment service provider to another. So they collaborate and share information between themselves. And then you have monitoring systems. So you have monitoring systems relying exclusively on information provided by right holders. So these are kind of IP protection program put in place by certain intermediaries, whereby you can upload your information and let the intermediary know what type of IP rights you have and what they should look out for. Then you have IP protection programs that not only rely on information from the right holders, but also use different systems such as keywords or images, and look for patterns that they are aware of that can indicate on IP infringing activities. And then, as I said, most of these intermediary services also have put a notification system put in place. Here you can see that we are actually referring to a certain article in the Digital Service Act. So we have made this distinction because some of the intermediary services, they go above and beyond what is required according to the Digital Service Act. So this could be other obligations that they look into, or allow for other kind of notification activities rather than the ones specified by the DSA. And then cooperation. So here we have cooperation with specific IP right holders. So we divided into two subcategories. So you have structured cooperation between an intermediary services and selected right holders. But then you also have systems or access system for right holders to gain access to certain tools to help in the enforcement of their rights. And then when we have this cooperation with public and or law enforcement authorities, we have three categories here. We have the voluntary collaboration on information sharing. So this could be certain kind of sectors that are focusing for sharing information and intelligence between the right holder and public and law enforcement authorities. But you can also have intermediaries participating in specific kind of actions taken by law enforcement authorities. I'll show you some examples. We have certain examples from Europol that's collaborating with various intermediary services. And then here is the collaboration on information gathering. So it kind of goes hand in hand with the sharing of information as well, but we made this distinction due to the information that we have discovered whilst we write these papers. So as I mentioned, in terms of participating in specific law enforcement activities, you have payment, for example, has been taking part in different actions from Europol. Here Europol doesn't share really information on who is participating, just more the sector. So these are kind of more generic in the sense that we don't have a specific payment service provider or a social media or an app store provider, but these are just examples. You can see here as well, it's not just one intermediary services that are participating in a certain action, but it could be two or three. So for example, Operation Aphrodite here, that we can see an example of here. Europol actually collaborated with payment industry, but also social media. Because, well, as we all know, it's not just limited to one service, but normally payment facilitate the IP infringers to get revenue, but then social media is being misused to kind of promote these or create closed groups where they can either give information or help their users to find details or find places where they can buy counterfeits or get access to illicit content. Then we have some examples on the collaboration on information sharing. We know, for example, in France, the payment industry are kind of meeting, and they have put together a committee where they exchange information and ideas to kind of try to get an understanding on how the payment service providers are being misused. We have the infringing website list. I'm sure you're all aware, Wiper Alert, where you can, there's a list where you can upload details of infringing websites or apps that has been deemed being used for sharing illicit content or selling counterfeits. And then you have an example from the domain name industry as well. So then voluntary sectorial or cross-sectorial cooperation agreements. Here we can see certain cooperation agreements between just intermediaries, either from the same or different sector to support IP enforcement on their services. You have cooperation agreements that includes everyone. So it's an agreement between intermediaries, right holders, and also public authorities to support IP enforcement. And then, as I mentioned before, you have cooperation agreements between intermediaries and right holders. So here it's sometimes it's a mix and match between different stakeholders. So we have tried to kind of separate them into more specific kind of different type of cooperation agreements. So depending on who's part of that cooperation agreement, they end up in one subcategory or in the other. And then IP awareness campaigns and communication. As I said, yeah, intermediary services are also doing campaigns or communications to inform their users on how to not to infringe other people's IP rights, or that their services can't be used to infringe other people's IP rights. And then some of these intermediary services are also kind of collaborating with public authorities or right holders to create these campaigns. And that's a lot of information. I'm sorry for that. But that is how we kind of foresee this repository on good practices, and how we have tried to kind of divide it into subcategories, but then also go into specific examples that end up in different. You would have noticed from the presentation that I didn't go through them all or gave examples to them all. The fact is that, well, first I didn't want to take up the entire morning here or afternoon for you, but then we're currently populating this repository, so we're not really done yet with the good practices. But then we also have the trends. So that is a repository which is a bit more tricky to create. We have started it, and we will do something similar that we have done for good practices, but these are a bit more specific in terms of different sectors. But what we have tried to kind of do, so similar to, if you remember, we had this wheel when we talk about terms and condition, know your business customer, etc. We have tried to do something similar in terms of trends. So, but we're breaking it down in kind of the life cycle of a counterfeit, or if you want to, life cycle of illicit content. In that, we first look at the production and sourcing. It's the production and acquisition of infringing goods, or different parts of goods that are kind of being put together and then infringe. We have the transportation of these goods. We can see certain trends within the transportation that you either contaminate other goods, so genuine goods with fake goods, or you do a full concealment strategy. So you transport counterfeit goods solely. And then storage and distribution. Here you can use then different type of So when it comes to transport and logistics, for example, you can use free trade zones to hide kind of infringing goods and then ship it broken down, or you use these free trade zones as a hub to kind of put different type of goods together and so create a counterfeit. But you also see promotion of IP infringing goods. So the online ad system ecosystem is definitely used for that. And then monetization of financing, as I mentioned, is not just revenue from actually selling the counterfeit or giving access to illicit content. These IP infringer or illicit actors are earning money on different type of activities, not just the sale of the infringing goods, but also malicious advertising, for example, stealing information from their users, etc. And then you have certain evasion techniques. So they use VPN, they use different techniques to kind of try to avoid or at least delay detection and enforcement from law enforcement authorities or the right holders. And then it's funny to talk about customer relation when it comes to IP infringing activities, but in effect we've seen certain of these IP infringers, as I mentioned, they have social media groups or they have WhatsApp groups whereby they give support not just to their users but other IP infringers as well, and exchange information and tips and tricks on how to best kind of either avoid detection or what technology to use in order for having the best kind of quality or product to offer their clients. So that is something that we're working on. It's a bit more tricky. It's a bit more specific to each sector, but we're hoping that this type of structure is clear enough and kind of follow the life cycle of a product and giving examples from different sectors. And with that, I think that was my last slide.